My name is Giselle Jeha, so good afternoon, everybody. I'm an innovation officer at the Canadian Intellectual Property Office, and we're here to speak to you today about IP. I'm joined by my colleague, Catherine Vardy, who is an IP advisor and represents us in the Atlantic region. So together we'll go back and forth and we'll go through the presentation. If at any time, again, just to reiterate, if you have any pressing questions, you can definitely pop them into the chat, and one of us or the moderator will we'll try to get to those questions. If not, we will have a little Q&A period at the end of the presentation. Hopefully we have a few minutes at the end where we can ask those questions as well. Okay, so I'll go ahead and get started. Okay. So as part of a positive collaboration with the Women's Enterprise Organizations of Canada, we're happy, CIPO is happy to present this webinar on women in innovation, develop a plan for success, to the clients and any other women entrepreneurs and any entrepreneurs that may have joined us today. Again, as part of a 3-part learning series, so this one's the second, we do have another webinar coming up in December on traditional knowledge and IP. So you can start registering for that as well. Today, it's going to be our goal to give you the ability to recognize intellectual property or IP and guide you on how to build an IP strategy. So we'll go through a few of the steps there. The webinar has 3 goals: to understand the challenges facing women entrepreneurs, to understand what IP is and why it matters, and to learn how to go about developing an IP strategy. And just bear with me, it's my computer's a little slow at advancing the slides. All right, so a little bit about us. IP rights are territorial, so they are managed by different IP offices around the world. In Canada, it's the Canadian Intellectual Property Office that is responsible for the administration of most Canadian intellectual property rights. So at CIPO, we register and grant IP rights such as trademarks, patents, industrial designs, and copyright. CIPO is part of the Government Department of Innovation, Science, and Economic Development Canada. And in addition to administering IP rights, we also provide a quasi-judicial function for trademarks and patents. And we work to raise awareness for the effective use of IP. To this end, we provide a range of products and services that are free of charge to help Canadian companies gain a better understanding of the importance of protecting and managing their IP assets. And I'll share some of these at the end of the presentation as well. We do focus on a few key growth industries, including advanced manufacturing, health biosciences, digital technology, agri-food, and clean technology. Okay, so what do you see when you picture a scientist? Is it a white man in a lab coat? When you think of a software developer, is it a young guy in jeans that springs to mind? So everywhere you look, it seems that it always appears that the odds are stacked against women in science, technology, engineering, and mathematics, so STEM. And there are many stereotypes that can prove difficult to break. But we are seeing things are changing, and for the better. So female innovation has made a significant mark on our history. Female inventors can be credited for momentous inventions such as windshield wipers, the first computer language, and even the Mars rover. I'm sure many of you are familiar with the Estee Lauder companies, a cosmetic company that was founded in 1946 by American businesswoman Estee Lauder. She was the only woman on Time Magazine's 1998 list of the 20 most influential business geniuses of the 20th century. So Estee Lauder companies, they now sell products in more than 150 countries, and many that you're familiar with. So they sell under brands including Clinique, Tommy Hilfiger, MAC, London, and Tom Ford, which are all trademarked. So very big. And this legacy has now gone into the 21st century with many women entrepreneurs, and too many to name actually. So I will just point out, for instance, Sarah Blakely, which many of you might be familiar with, Spanx. So she is the inventor of Spanx, and just at 27 invented these with a pair of scissors and a pantyhose. And actually, after failing to find an affordable patent attorney in her state of Georgia, she actually went out to Barnes and Noble's, purchased a textbook, and wrote her own patent. So in 2014, she was actually listed by Forbes as the 93rd most powerful woman in the world. So very big accomplishment. In 2015, Fortune listed 24 female CEOs of Fortune 500 companies. And in 2020, the number actually went up and is now indicating 37 female CEO leading companies that have made the list of this year's Fortune 500 companies. So things are moving in a good direction. So this slide is just to take a look at where are our small, medium-sized enterprises, so our SMEs. As of December 2018, the Canadian economy totaled 1.2 million employer businesses. Of these, 97.9% were small businesses. 1.9% were medium, and 0.2% were large businesses. So with more than half of Canada's small employer businesses concentrated in Ontario and Quebec, as seen on the map here. We also have a large concentration of SMEs in Western Canada. So you'll see led by British Columbia and Alberta. So it's no secret that there are challenges and barriers that face women entrepreneurs. So we'll just discuss a few of those today. According to the 2017 survey on financing and growth for SMEs, it indicated that women are underrepresented among business owners in Canada, with only 16% of SMEs being majority owned by women in 2017, compared to 63% of SMEs that were majority owned by men. Despite general improvements in gender equality around the world, gender gaps in patenting in particular persist. So WIPO's data, the World Intellectual Property Office, WIPO, their latest data show that 30.5% of international patent applications filed via the organization included at least one woman inventor. While this is encouraging that the number of PCT applications with at least one woman inventor has nearly doubled since 2007, gender parity remains. Because assuming that the trend continues as it has been going, they estimate that the numbers are only going to balance out in 2076. So that's too long, I think, for that to happen. And although inventors who are men still outnumber those who are women by a 7-to-1 ratio, there is improvement. This is better than the 9-to-1 ratio that was seen in the late 1990s. So again, just showing you that, yes, there is challenges and barriers that still exist, and definitely not only these listed here, there are many, but we are seeing things move in the right direction. So the government of Canada has set targets to try to close this gender gap and address some of the issues that, that women entrepreneurs face. As part of the Government of Canada's Innovation and Skills Plan, which is aimed at growing the economy, creating middle-class jobs, and providing Canadians with the skills they need to succeed, it has established several goals. One of these targets under this Innovation and Skills Plan is to double the number of SMEs majority owned by women to 340,000 by 2025. And that's the progress so far. On the slide, you'll see where we stand today. The targets and progress are available on the Innovation, Science and Economic Development Canada's website if you look under Innovation and Skills Plan. So you'll see all of the targets, including this one that we are going to talk to and address today. So as part of the targets that the Government of Canada has set, they have put into place a plan of action. So specifically for the target to address the challenges facing women entrepreneurs, which I mentioned in the previous slide, they have created the Canada's the Canada's Women Entrepreneurship Strategy. So what this is, it's the first ever Women Entrepreneurship Strategy, or WES, a nearly $5 billion investment initially launched as part of the 2018 federal budget, which aims to help double the number of women-led businesses in Canada by 2025. It is aimed at building more inclusive innovation and entrepreneurship ecosystem. And in addition to direct investments in women-led businesses, the government is investing in organizations. So they're actually reaching out and expanding to organizations across the country that support women entrepreneurs to join them in providing information and resources to help tackle this target together. So on this slide here, you'll see just 3 out of the many resources and organizations that are providing tools and resources aimed at supporting women entrepreneurs. For a full list, I do have the link below on the slide, which you can log on to see the WES strategy, and they'll have all the resources listed there. But again, this is just 3 of the ones that I'll just quickly mention today. The first is the Women Entrepreneurship Knowledge Hub. This is a very good consolidation of information and tools to support women. So what it is, it's a sort of a one-stop shop for a bunch of resources and tools aimed at helping women entrepreneurs. And what they've created is, in partnership with the Forum for Women Entrepreneurs, they've actually created a sharing platform. So they launched this platform where it's accessible to everybody. And the aim here is to help women entrepreneurs and the women who support them across Canada easily connect. It's available in both English and French. And so the sharing platform allows members of the women entrepreneurship ecosystem to draw from the knowledge and reach the community and share their own learnings to access business opportunities. And collaboratively, they can tackle challenges together. So to give you an example of how the platform works, if you have a question about something, you can pose and ask on this platform, and then members of this community will they can respond to that ask. So it's kind of a peer-to-peer learning, or also mentorship opportunities, right? So depending on who is part of the community and responds to your ask. The other way it works is if you have something to offer. So if you have beneficial information that you'd like to share with the community, you can offer what they call a give. So it's asking and giving. So it's a really neat platform that they've launched. The second one is the Canada Business app. Simply put, this is a mobile app that's available to download, and it provides direct access to Government of Canada services and tools. So easily something to have at your fingertips, and kind of consolidates all their services and helps you navigate through the Government of Canada resources. And I believe this is in one of their earlier phase. They're in one of their earlier phase versions, so there will be an update coming to this one. The third one I have is Futurepreneur. This one, again, I just singled out. I thought it was an interesting organization. They provide financing, mentoring, and support tools to aspiring business owners, which are aged 18 to 39. They have an internationally recognized mentoring program that hand matches young entrepreneurs with business experts from a network of more than 3,000 volunteers. They are also partnered with the Business Development of Bank of Canada in order to provide additional funding to some of these businesses. Even if you fall outside of this demographic, I did highlight it because they do have several resources on their website, which would be of use to, I think, any business, which includes crash courses, videos on getting the most out of every startup dollar. They have guides on building a strong business plan. They have cash flow templates, and they have over 17 business plan examples for various different industries. So they have lots of examples that you can kind of pick and choose from and take a look, and that's all available on their website. So now I'll actually hand it over to my colleague Catherine, and she'll just go through now the meat of the presentation of why what intellectual property is and why it matters. And sorry, I'll see if we can unmute you, Catherine.
Hello, I think I have been unmuted. Thank you very much. So I'll go through some of what we've talked about briefly in the past, but also a few other additional topics, because we don't want to, those of you who were able to participate at the previous session, we don't want you to have to sit through the whole thing a second time. Next slide, please. So when we talk about intellectual property, you might hear the term intangible assets, which people are like, well, what do you really mean by that? Intangible assets is, in the past, a company would have had things like buildings, maybe a manufacturing plant, they'd have inventory, maybe even desks and chairs. Those are what we think of as tangible things. But now, if you stop and think, what types of companies are many people starting, and what types of companies do we have in Canada? A lot of them rely on apps or data, or it might be a trademark or things along those lines. And those are what are referred to as intangible assets. But those also have value. And so this shift to more the knowledge-based economy, as we call it, means that the ownership of what has value for a company and makes up its worth, if it's going to be selling a product or going to the bank for a loan or maybe being bought out by somebody else, those are the things that get assessed as to what the value is. And now part of that, more and more, includes intellectual property. Next slide, please. So it's been shown that the companies who do have intellectual property are more likely to export. They're more likely to be high growth and expanding quickly. So in the scale up phase, which is a term you may hear, and they're also the ones that are most likely to seek financing. I would add that they may also be the ones that are more successful in getting financing. If any of you have watched Dragon's Den, for example, one of the questions they'll sometimes be asked if you're pitching is, who is your competition and what prevents the competition from getting ahead or copying you? And often, again, the answer to that will lie in intellectual property and how they've protected what's distinctive to them, whether it's in a very physical form for an invention, or whether it's a web-based platform or more reliant on computer code, an app, or a website. Next slide, please. So just in case not everybody was at our previous session, I do want to do a quick review of what are the tools in our intellectual property toolbox. And there's an analogy I regularly use to describe what is intellectual property. Many people will have heard of a trademark, will have heard of a patent, may know the difference, or maybe a little bit fuzzy as to what is the difference. So here's the analogy I like to use. If I want to build a house, I will use different tools, and there will be different tradespeople. And an electrician is different than the plumber that needs to build my house and give me all the functioning systems I need to have a house. Well, if you're building a business, there are different intellectual property tools that protect different elements of your business and what's unique to you and what you're doing. So in business, your intellectual property is what sets you apart and what makes you different than your competitors. And another way to think about it is consider all the information or knowledge you have in terms of the activities. Are you marketing and advertising? Maybe you're doing a little bit of research and development, or most companies now will have a website. You may have packaging, you may have client lists, you may have a strategy of how you're going to bring your product to market. All of those are forms of intellectual property, and chances are you wouldn't want your competitors to have access to those or be able to copy them outright without you being able to go, hey, wait a minute, that's mine. Next slide, please. So the first tool that every single company has is a trademark. So it's a combination of letters. It can be words, a symbol like a logo, sound, design. We've now even added moving images or little animation, holograms. All of these can be protected with a trademark. And just like with, I like to say with marriage, you can have common law and you can have registered. So if you launch a product and you've named it and you did not register it with SIPO as a registered trademark, you do have common law rights. Now, you do have to be careful that somebody didn't beat you to it, and hopefully you did a little bit of research to make sure that in Canada, nobody else is using exactly that name for a product you're launching or for even the name of your company. If you have and you register your trademark, it gives you the right to exclude others from using that trademark. So that logo, that word, that series of words for a similar product or service. The idea is to avoid confusion as to where those products came from. And with the Canadian system, you get protection for 10 years for all of Canada. And this is the only one of our tools that's renewable indefinitely. So there are brands and trademarks that have existed in the marketplace for years and years and years, and they get renewed and they continue to be used. Tide detergent has been around for more than 10 years, and every year Procter & Gamble, I'm sure very carefully, renews their trademark so nobody else selling laundry detergent, for example, could use that name. And the difference between the common law and the R in a circle or registered is how you can add a notation to that brand or that name. So we'll often see a TM on packaging of a product. That's while it's common law. Now, the company might have applied for their trademark. It just hasn't been granted yet because it is a process and it takes a little bit of time. But whether you're using it strictly common law with no intention to register, or you have started the registration process, you can put that TM. The R in a circle can only be used after you've received your final step in the registration. And so we have different types of trademarks. They're what are called ordinary marks. There's also certification marks like the wool mark logo or certification for Harris tweed, if you happen to know about fabrics. That certifies that that particular goods, usually it's for physical goods, came from a specific source. There's also what are called distinguishing guises. So if you become recognizable, like the triangular packaging on a Toblerone chocolate bar, they made a case that said, if I gave you a chocolate bar in that kind of wrapping, even without the name Toblerone on it, you would recognize it as a Toblerone chocolate bar coming from that particular company and brand. So that can be protected if you can make a claim for distinctiveness or distinguishing guises. And then there are non-traditional marks, which can be, as I said, for sound, for holograms. And now we've added certain scents or smells and tastes. Next slide, please. So it is, however, though you can certainly start and launch a product without registering, it's usually a great idea to register. In Canada, you're allowed to do that and just go with common law, but it can cause you issues because your rights under common law rights are going to be geographically limited. So I happen to live in Nova Scotia. I may launch something, it's going great guns. Well, what if somebody else has launched something out in British Columbia or in Manitoba or in another province? It can get snarly to defend common law trademarks or rights as you expand. So it's usually a heck of a lot easier and simpler to protect your rights by officially registering them. This is incredibly important when you want to expand, either within Canada and especially in other countries. So China, for example, you need to register your trademark before you launch a product. They don't have the same rules. And so there's an example with La Vie en Rose, a lingerie company, and they have 300 or more than 320 franchise stores in 15 countries around the world. So when they wanted to expand into China in 2003, they learned that they couldn't get the trademark in China because somebody had already registered it. And there are squatters who do this, just like with domain names. And so they were prevented until 2006 from using the same name and logo that they've built this reputation and brand on. And they couldn't use it in a store. They couldn't use it in any of their marketing. And I've also personally, as an IP advisor, had people sitting or, with whom I've interacted to say, tell me about what you're doing. What is it your plans are, who wanted to expand just into the US, but their trademark was not available in the US. It was only available in Canada. So these are the kind of things that working with an IP advisor like myself and IP professionals can be really helpful to map that out in the early stages, as opposed to getting all this traction under your belt and then realizing, darn, we had plans to go to the European market, into the States or other countries, and we can't. So with coming back to the story with La Vie en Rose, they ended up working with the Trade Commissioner Service for Canada, which is an excellent resource if you're going to think about exporting. And they were able to hook up with a law firm in China that specialized in intellectual property issues. And they finally managed to get their trademark registered in China, but not until 2015. So that was a lot more expensive and a lot more complicated than had they registered it early on or looked into this from the early stages. So I get it. As a startup, as small companies, time and money are at a premium, but kind of mapping out your strategy and being aware of who's doing what and what's available can be really helpful. Next slide, please. So patents are another really important tool. And one of my pet peeves is patents sometimes monopolize the IP toolkit in that they're the one thing that people think about a lot, and that's great. And they're a wonderful tool, don't get me wrong. But every single company has trademarks. Not every company is going to have patents, but when you have a need for a patent, it is totally the right tool to be used. So patents can be filed and obtained for anything that's new, useful, or an invention that isn't obvious. One of the kind of tests that I would say, if I'm sitting with somebody and they're saying, well, I don't know, should I get a patent? And it's like, okay, if I was to buy or see your product, could I reverse engineer it? And if I could reverse engineer it and it's inventive enough to qualify for a patent, then a patent is the right tool. Now, a patent doesn't give you the right to make it and sell it. It gives you the right to prevent others from making, using, or selling it, again, in Canada. So if you get a patent in Canada, that doesn't protect you in the US. So patenting strategy is important because if you're planning to eventually expand into the US, the timing of when you get your patent in Canada and how you go about it needs to be done with a mind to making sure you're also protected in the US when you expand. We won't get into that here, just be aware of it. But what it does is it gives you that right to exclude for 20 years from filing. And in exchange for getting your patent, though, you have to fully disclose and describe what your invention is, exactly how it works, with the level of detail that somebody else could copy it. But your patent prevents others from doing that in any country where you've got the patent. So think of it this way. Many of us have at some point in our lives had to take a prescription medication. And we know about brand name prescription medications versus generics. So the way that works is the drug company gets a patent for 20 years, which means they're the only ones who can make and sell that drug. But after the 20 years are up, that's how you get generics, because they've had to describe exactly how to make it, what it does, all the details about it. They get the 20-year head start and exclusivity in exchange for all the work they put into developing that. But after 20 years, that patent expires and other people can make and sell that product. In this case, a generic drug. Now in Canada, we do have what I call the oops factor, which is if you've launched your product or you went to a conference or a trade show and told people about what you're planning to do, you can quickly apply in Canada to still file for patent protection. In other countries, if you've let the cat out of the bag, you are now no longer able to get a patent. Now that is sometimes a strategy. Let's say I develop a way to filter safe drinking water. And I don't want anybody to be able to patent it and have a monopoly because I want it to be used for the greater good. Well, if I publicly release what that is, what's my methodology, how it works, then nobody can get a patent for it. So it's first to file as well. It's not first person to invent. So that's a key underpinning of our system and how things work. So the kinds of things you can patent, it can be a process, it could be a machine, it could be a product, a composition, or an improvement to an existing product or patent. So if somebody else already has a patent and you come up with a better, either what's called an addition or a substitution. So the Gillette razors used to have 2 blades. And that was their claim to fame. And they had a patent for that razor to say, that's the best shave you can get, whether you're a man shaving your face or maybe a woman shaving your legs or your armpits. So they came up with, though, what if we add a 3rd blade? So they were able to get a patent for that. However, if they hadn't owned the original patent for the 2-blade version, they would have to enter into a licensing agreement for permission to use or improve an existing patent if it was still within that 20-year window. So if you've invented something that you think qualifies for patenting, you need to check and search, is the coast clear? Has somebody publicly released what you want to patent, or has somebody already patented it? Maybe they have already patented it, but your variation is an improvement. That might still be a business opportunity, but you need to assess that before you launch your product and make sure, as I said, the coast is clear. Next slide, please. So kind of the opposite of getting a patent, where you have to describe exactly what it is and exactly how it works, is you're going to do the opposite. You're going to keep things a secret. You do not register them with anybody, and that will last as long as your confidentiality or the secret is maintained. So WD-40, when they invented WD-40 and they said, hey, we've got this great product, it removes rust. If I've got a bolt that's stuck on the nut on my wheelbarrow and I have to replace something, this is just the cat's pajamas and is great for solving this problem. Had they gotten a patent for it, they would have had that protection for 20 years, but they would have had to fully reveal what was their secret formulation and how it's made. Well, they decided instead to protect it as a trade secret. So for that, they don't tell people about it. They keep it a secret. Maybe not everybody in the manufacturing plant knows what ingredients are added and in what order and exactly how all the steps of the process go and in what sequence to make that product. And it's reported that the Coca-Cola formula or the recipe is actually stored in a vault somewhere, and only 2 people in the company know it, and they can never travel on a plane together. And, you know, there's all these secrecy agreements that are signed. And so really the way you keep a trade secret is you encrypt files. Only the people who really need to know the information know it. And as we like to say, you lawyer it up. You know, you have an employee agreement, you have non-disclosure agreements, and you have to show that you've taken the steps necessary legally to make sure that stays a secret. If you want to then pursue someone for infringement of a trade secret, you're going to have to prove how that got out and that you really had taken all the steps necessary to keep it a secret. However, as long as you keep it a secret, it keeps the door open later on if you decide you do want to get a patent. So as a startup or a young company or a small company, if you're really careful at this stage, it still does leave the door open for you if later on, as you grow and cash flow helps and you get angel or venture capital investment, you could then decide from a strategy point of view to get a patent. And that will still be open to you because you've not disclosed. Next slide, please. So an example of a trade secret is that Sensational Technologies, which was a company, claimed to have invented a process to add aroma to the lid, the little liner of the lid when you open a bottle of pop, in order to enhance the consumer experience. This was part of their marketing strategy. And their plan was they wanted to license this technology, but their plans were ruined when Pepsi allegedly broke their confidentiality agreement and then went ahead and patented their own technology. So in court, and you can imagine these big corporations, they have teams of lawyers and a lot of money was spent, but it was proven that Pepsi did not break the trade secret and the non-disclosure agreement. And so the documentation was found to not be sufficient. And so just to underline the importance of, if you are going to use trade secrets, please don't just download a template from the internet for your non-disclosure agreements. Yes, use that as a way to inform yourself, but make sure you talk to a lawyer and get appropriate measures in place to really protect what's important to your business and that you're trying to protect with a trade secret. Next slide, please. So another tool that does come up, maybe not all of you are authors or musicians or writing plays, but I'm willing to bet you most of you have a website, and lots of companies now have software code and apps. So copyright is the tool in our toolbox that does help us protect elements of the website, because your writing and what photos you choose and that hopefully you've gotten permission for are all protected by copyright protection. Now, you do get automatic rights because of the Berne Convention, which was signed by over 180 countries and is recognized around the world. I would say if you have a piece of very distinctive software code that is not changing every week or every 2 months as you get customer feedback, it may or may not, that's a business decision, but it may be worth registering and filing and protecting certain aspects of what's really important and proprietary to your business. If you're doing training and you have training manuals or proprietary information you created that very clearly spells out certain things, you may want to look at using copyright as a tool, and that will protect any work for the life of the creator plus 50 years. Now, be aware, if you hire somebody on contract to build a website for you, technically by letter of the law, the creator of the website owns the copyright. So make sure your contract with your web developer says that the copyright is going to be company property. Otherwise, you've paid for the service, not the copyright. So that does also come up for a lot of small businesses. Next slide, please. So I think I mentioned already that computer code is considered a literary work. Okay, maybe it's not Jane Austen or War and Peace, but it is considered a literary work. So it is a series of instructions in code, and databases are also protected under copyright. So copyright also matters if you're using open source software. You need to read the fine print of the terms and conditions. Quite a number of open source software codes that are pre-written can be used for commercial purposes, but not all of them can. So if you're doing an app, you need to talk to your developers who are writing code. First of all, if they're an employee, then their code belongs to your company. If they're contracted out and they're writing code for you, you may not own the copyright to that code. Again, that needs to be specified in a contract. Get some advice on that. And I'm happy to help people with resources if that's the space that you're in. There's a lot about the IP implications of open source software, the IP implications of apps, and the IP implications of sort of software in the digital space. If you do a search online, you'll find lots of easy to read articles and things like top 5 or top 10 things you should be aware of. Next slide, please. So in terms of industrial design, this is kind of the church mouse of the of the IP toolkit. A lot of people forget about industrial designs, but again, depending what you're doing or making, they can be a really powerful tool. They protect the shape, configuration, pattern, ornamentation, or combination of these features of an article. So it's not how it works, but it's how it looks. And how it looks, if you're a jewelry designer or a fashion designer like Lululemon, who has the curved seams on their logo and on their hoodies, for example, that follow the same shape as their logo, that's a form of protection. And Lululemon actually has a lot of industrial designs for their sports bras, for their yoga pants, sunglasses, sometimes the shape of certain phones, like the rounded corners at one point were protected, or a food product. Again, the Toblerone bar started out being protected with an industrial design for its shape, and it became well enough known that then they flipped it into a trademark. But right now there are shapes of chocolate bars that are protected by industrial designs that are new products that are being launched. So you get protection again to exclude others from copying the shape of your packaging or your product, assuming you meet the criteria, and you get protection for up to 15 years. Once again, you should keep that shape or design or ornamentation a secret before launching your product. You should file first, then launch. The design that's stamped on toilet paper and paper towels, those are protected by industrial designs, or certain lines of fabric with floral designs that are recognizable as to who that designer was. Those are often protected by industrial designs. So that again can be a really important tool depending on what type of business you have and what type of product you are offering. Okay, next slide, please. So the idea is to take all of these tools to help create a plan. And really the point of an intellectual property strategy is to say, what am I doing? What product am I offering? What service am I offering? And then what does that mean from an IP perspective? Next slide, please. So first and foremost, as you can imagine, a really good place to start is to say, okay, I've come up with this idea for what I want to launch. Did somebody beat me to it? I might have done a search online, but does that tell me that whether or not somebody has patented it or registered an industrial design? Actually, no, it doesn't necessarily. So looking for what intellectual property you might have and determining what you have is really important. And then thinking about where are you going and what are you mapping. So I'm going to switch it over back to Giselle, and I'll see you again soon.
Great. Okay, great. Thank you very much, Catherine. So as Catherine introduced us, once we have a good grasp on the IP rights, we're going to talk about now putting a plan in place, which is essentially what the IP strategy is, a plan to manage those very valuable intangible assets that we have. So there could be many reasons of why we need an IP strategy. For instance, if you have IP, have you secured your invention? Are you thinking of exporting? Would you like to sell your product, make money? And there's many other commercialization avenues as well that we can go into. But they're all reasons of why any business would need a good IP strategy. So you don't want to just jump straight into filing a patent, for instance, without asking, okay, well, I have a patent now. I spent all this money on it. So now what? What next? What can I do with it? So there's a few steps before that should actually happen. And that's what we want to kind of emphasize today, is the importance of building this IP strategy. So you have that plan in place to know what to do, the steps to do, and what the outcomes will be. So for example, for a company that's developing groundbreaking technology, an IP strategy isn't necessarily just filing the patent application. That's not what we mean by IP strategy. The strategy here is the process. It's the process that allows you to identify whether you should file for a patent, because you might actually find that you should go, based on your business goals, your direction might be to keep it a trade secret, so to keep that information confidential. And you still might end up with the same outcome to achieve your goal. You went about it a different way. So another example for a data company, again, the IP strategy is not that company keeping that data confidential. That's just one step. It's the whole process to identify what your confidential data is, how to retain it, and how to manage that. Let's go to the next slide. So on this slide, we're just outlining here, it's just to show you that with starting out for any IP strategy, the first question to ask yourself is, what are your business goals? So most business models are based on a priority to either make and sell products or to sell services. Or it might be that you want to create some assets, not with the intention, based on, you don't intend to actually use them, but you intend to create them to sell them. So you're going to license them to others. Or it can be that you want to attract investment. So once you've figured out your business goals, now it's time to identify what you need to create a plan to achieve those goals. So for instance, you should identify your assets, and this could be your technology, this can be your employees, it can be yourself, the contracts you have with your clients, and so on. Next, you'll need to ensure that you have a market for your products and services. So if you haven't done that research and you've created this great product, but you haven't actually figured out whether there's a demand for it in the market, well, it's not going to go it's not going to go anywhere, or likely the chances are you're going to have a hard time getting it sold. So just very important to check that marketplace. Next, you'll need contracts to cement your agreements and relationship with that you have with your business affiliates, that you have with contractors, any other clients, suppliers, your employees. So all these agreements are very important to put in place. And lastly, an important aspect to any business, especially a business that's growing, is that you need to make sure that you avoid lawsuits. And we'll get into that a little bit more in the next few slides. So on this slide here, it's just to show you there's several approaches to building an IP strategy. This one is just one methodology that we'll run through today. So we're going to walk you through those steps right now. Also, just to let you know, again, here we're walking through the steps pretty quickly, but we do have an in-depth seminar and webinar that we actually have available on our CIPO's YouTube channel on IP strategy, and that will provide actually more detail on each of these steps. Let's look at step one, internal audit. So as a first step, it's important to properly assess the importance of the company's IP assets. For example, if you have a technology-based company, it is recommended that you understand what your company's business plan is as it relates to your company's products, present and future. So look at your 3 to 5 year plan, look at your long-term plan. All of this needs to be taken into account. Which products are you going to bring to market first? So once you've kind of thought of that, now you can start to create a catalog of all your IP that your business owns. This doesn't just include formal IP registrations. You need to look at those unregistered forms of IP assets that you may have. So consider any valuable information that your company may own. This could include customer lists. This could include price lists, trade secrets, know-how, common law trade names, which Catherine spoke about as well, and so on. So for all of those unregistered rights, it's important that you record the creators, that's the inventor, the author, those could be different people, the dates of first use, the date of creation, and any employment contracts that are in place. These are very important. This is very important information to have and evidence to be able to provide if, for instance, you find yourself having to defend, or you find yourself one of your trademarks against a potential competitor. So the more information you can record, the better. For taking stock of your IP, if this is the first time you're looking at your IP, CIPO does provide an IP inventory checklist. This is just a screenshot of it, and it's available at the link provided on the screen. This is a very useful sort of one-pager that actually includes, on the left-hand side, you'll see the intangible assets that your company may have. So for instance, a domain name. And then on the right-hand side, you'll see what potential IP could be, form of IP protection you can use to protect. So just a good resource that we have in our toolbox on CIPO's website. Step 2, external audit. So for this, in this step, you'll learn about the IP around you. It's very important to look outside of your company and not just within. So here you're going to identify competitors and their IP. This knowledge in turn becomes your IP landscape and informs your decision making. So why is it important to learn about your competitor's IP? Well, first, you want to reduce the risk of getting sued. You have to assume that your competitors are just as smart as you. So they may be working on a similar product as you, and you might not know without doing this research first. So it's important to look to see what types of IP a potential competitor holds for this similar product. If you're lucky, you'll find out exactly what patent is out there that your competitor has, and you can avoid infringing on it. Or you can try, if it already exists and a competitor has already patented that technology that you need, you can look at avenues such as licensing it from that competitor as well. To conduct these searches, there's many preliminary searches that you can do on your own. We have them listed here. Again, these are preliminary searches. They're not exhaustive, so it is recommended that after you kind of do your own research, you do consult an IP professional, and our IP advisors can help kind of gear you in the right direction, not only on the use of some of these searches, but once you've completed these searches, the preliminary searches, kind of who else to contact, which IP professional to contact to complete a more comprehensive search. So just to name a few, the Patentability Search. This lets you know whether your invention is patentable. So for instance, WIPO offers a patent search database, which is a great tool to use as well. So you can go on the World Intellectual Property Office's website, WIPO, and they have a patent database that you can use. Patent validity. This search will let you know whether a competitor's patent is valid or not. Because for instance, if a patent is found to be invalid, then you may assess the risk of bringing your own product to market. Freedom to operate. This is a non-infringement search. This search is to determine whether you would infringe any patents if you were to bring your product to market. This can be really costly though, and might be needed in certain jurisdictions to ensure you don't pay heightened damages at a later stage. So although there may be upfront costs now, it could save you more money in the long run because you might find yourself in some deep water afterwards. And something just to keep in mind with any of these searches is that it probably won't be a comprehensive search because patents aren't published. Patents are published 18 months after 18 months, and before that, they're not laid open, so they're not published, and there's no way of knowing what patent applications are currently in the works. So you can't find out what information. There may be a patent, in progress, but that won't be searchable to you. Additionally, people may have, businesses may chosen to go the route of trade secrets. Again, this is something you won't be able to find out. Learn about that know-how. And lastly, trademark registrability. So for this, prior to launching any marketing or promotional material, it's important to search your competitors' trademarks. And Catherine had mentioned a few examples as well, and especially if you're thinking of doing business in another country, another province, it is important to expand your search into those markets of interest for you. In the trademark registrability search, also it's important to include domain names. So if you're going to be launching, most of us will have a website for products, so very important to look at that as well. Step 3, analyze. So within this step, we're going to be identifying any gaps and putting in place the actions to take to resolve those. So with this step, you'll need to have done step 1 and 2 because you'll use those findings from step 1 and 2 to identify any gaps that prevent you from achieving your business objectives. So for example, it is possible to have maintained a large amount of documentation on a patent portfolio that on the surface would indicate that the portfolio is in order. So everything looks fine. Patents have been issued, maintenance fees have been paid, they are in force. However, on closer inspection of the actual technology covered by those patents, it might reveal that the patent portfolio has very little to do with the products actually being developed. So actually, it's not a strong patent portfolio. Ownership issues. So here, do you own the IP rights required for your product, or is this something you'll need to go and acquire? new rights, either through registration of your own IP assets or licensing it from somebody else. For example, your business may be focused heavily on branding, and therefore all opportunities to protect those assets via a unique registered or unregistered trademarks. So you might need to, if you're focused on your patent portfolios, sorry, your trademark portfolio, that's what your business is focused on, you'll need to consider whether you need to acquire new marks for that portfolio, whether again, it be through registration or through licensing in. Reviewing contracts. So you need, at this stage, you'll need to review whether you have all your contracts in place, are non-disclosure agreements put in place with your suppliers, any contractors, employees, and getting basically your house in order contractually. Redundant IP. So this step here is to assess whether or not you need to remove any redundant IP or consolidate different IP rights. This actually might help save you money as well. So if you have, for instance, some IP rights, you have a patent, but you no longer, after doing an IP valuation, you've come to find that it's no longer, you don't use it. You're kind of just maintaining it for the sake of maintaining it. This is something that can be potentially abandoned. But again, another big business decision. So I do recommend that you do seek IP professional to help you kind of walk through those steps. And something not on, oh, I did put it on there. Okay, the standards. So this is another related area discovered in IP gap analysis when we talk about the subject. So products and services are often subject to a range of regulations and standards to ensure products are safe and that performance can be measured, compared, integrated, and so on. Sometimes a dominant technology is protected by a patent, which you may need to license if you want your invention to be part of the bigger system. CIPO actually just recently, in collaboration with the Standards Council of Canada, launched a fact sheet on standards and IP. And so I've included the link here because it does provide more information on the standards and also how IP can be embedded into those standards. And this can actually enhance a company's competitive advantage. So I do welcome everyone to go check that out. That is something new that was published. Okay, so for step 4 and on, I'll actually pass it back to my colleague, Catherine.
Okay, sorry, just took a moment there to unmute. Yeah, sorry, we had a wee bit of a glitch in terms of the transition previously, and I apologize for that. So in terms of creating a plan, really at the core of it is to say, what is it you're going to be doing? So acquiring, developing your IP assets. So what is it, the product or the service that you're going to be offering? Do you have a clear pathway to be able to launch what it is you're going to launch? Quality versus quantity, because again, as I said, time and money are sometimes in short supply, and you've got to balance that if you're trying to run a business. And often there's 1, 2, 3, 4 of you, because many businesses start with a small team or one person. And then also you've got to be aware of the management and the maintenance of it. Now, as your company expands, some of you may not be at a point where you're going to have an R&D or research and development policy, but Estee Lauder, when she started her company, didn't start with that, but certainly considered it later on. And a partnership policy. If you're going to partner with people, absolutely, it's very important to consider the IP and the implication of that, because you may require a partnership to get access to whether it's technology or other business relevant information. Sometimes you don't want to reinvent the wheel. If somebody else has something and you can collaborate with them. And that's another aspect of the intellectual property databases that can be really useful. Think about using those to find out who's doing what in your industry. And you may find somebody that you can partner with when you realize, hey, they already have a patent, it's already in that space, or they have a trademark and they're about to launch this product, but I have an improvement. Maybe that's a partnership opportunity. But then you need to be aware of how is that going to work. So I like to call those a company prenup, in the same way that what are you bringing to the table? What's the potential partner bringing to the table? And making sure you're well protected for what you brought and what will happen if you break up and you're no longer in partnership with them. Also a disclosure policy, which is if you've got salespeople going into the field, and especially in very technical products or services, how much can they reveal? Like, again, it's very wise to talk about the benefits of the product. It's faster, it's cheaper, it's more powerful, but you may not want to be disclosing what is, the secret sauce, so to speak, or unless you've protected it with a patent, you want to make sure your sales and marketing team, whether they're employees or contracted out, aren't revealing too much information. And same thing, the disclosure policy, if you're looking for investors, normally you want them to be signing what are called non-disclosure agreements, and that's part of your plan. And then HR, the minute, again, you start hiring people either with a contract or as employees, are employees and partners aware that what you've shared with them is proprietary to you? And part of the onboarding or bringing in new employees should, and hopefully does, include some training on what is intellectual property, how does it work in our company, even if it's only 2 people, what do we need to be careful of that we're not sharing with others that we really want to be keeping secret? And how do you manage documents? And what encryption might there be on documents that are being shared with others? Next slide, please. So some examples of how people address this, whether it's a company both big and small, you can have different approaches to how you're going to protect your intellectual property. Some companies are very, focused on product development and marketing, and they're not so concerned about protecting the IP. It's first to market. If you're running an app and every week or two you're getting feedback from your clients and it's evolving and it's changing, you're not going to maybe be filing intellectual property on that every second or third week or every second or third month, because that's not realistic. So in the early stages, you definitely want to be specific. And some people go really broad and some people go really narrow in terms of what they're protecting for their existing products or what they're planning to launch. But really, when you're looking at an overall IP strategy, you want to consider the reasons for protecting what you're protecting in the first place. So is it because you're hoping to license something out, or you're going to need it in order to attract financing, whether it's from a bank, venture capital, or you're looking at a merger or acquisition? So in all those cases, having aspects of your business protected by intellectual property can be really important. And sometimes people go offensive and sometimes people go defensive. There's different strategies and there's no right and wrong answer. What I would like to see, though, is that at least it's being considered, that decisions aren't being made out of ignorance because you don't know what you don't know, but that you make an informed decision as to what makes sense for you right now. A common phrase that I use with companies and startups when I'm doing a session with them is to say, I can tell you about the tools. We can talk about, well, you could do this, you could do that. But at the end of the day, it's your business. And you've got to make those decisions. And what are your priorities? But as I said, my goal is that you make those decisions based on good information. So sometimes a company might decide that, yeah, either I don't think I'm going to qualify for a patent to protect what I have, or even if I was to qualify, the cost to defend that patent doesn't make sense. And so there's no advantage to patenting. So using trade secrets might be a better approach, but that's going to be company specific. In other instances, a company might decide, yep, a patent is absolutely the best tool. That's what I want to do. This is, I've looked at what my choices are, door number 1, door number 2, or door number 3. And nope, I'm going the patenting route. I want a solid patent portfolio because my business is really tech heavy. It can be reverse engineered. And I've come up with a great way to do 3D imaging that's totally unique. And we did a search and nobody else has this. So those are going to be specific to that company. Next slide, please. So I think this has been mentioned a couple of times, both by Giselle and by myself. Really important for your employees and partners to know what's confidential and what's a trade secret, because that's part of the implementation. Making sure you've got good and clear assignment, licensing agreements if you're going that route. That you own what you have, so then you are in a position to license it out if you partner with folks. And keep monitoring the market and your competitors, because think of intellectual property as a snapshot, because it's constantly evolving, just as the business world is. Maybe right now, nobody else has a product like yours, but 2 weeks from now or a month from now, did somebody else launch something? Because we have more than one of everything. Like, I can't think of a single product or service where there's only one person I can go to for that product or service. That's how the market works. And no amount of intellectual property tools is going to grant you 100% exclusivity. Somebody else can write a different computer algorithm or code that will find me the cheapest hotel room or airfare or any number of product or service. So you might get, what they call first mover advantage if you're really the first in that area, but other people will be nipping on your heels. IP in that toolbox prevents somebody from copying outright exactly what you've done. So monitoring the market and your competitors is important. And you've got to be realistic as to how much money you can spend and time to protect what you have, but also then to defend what you have. And so that's important to be realistic about. Next slide, please. And you know what? Businesses are fluid things, and reassessing and realigning. Maybe you were going a certain way with a product or a service, and we've had and heard a lot about companies that are pivoting right now. With COVID, maybe the way they were going to do something or the product they were going to launch is no longer the same product. There are lots of microbreweries that are, or distilleries that are now making hand sanitizer. They are probably reassessing and realigning right now. Maybe they're filing a trademark for a line of hand sanitizer that 8 months ago, they had no idea. They were planning to sell vodka, but now they're selling hand sanitizer. So as your business goals and products change, you want to be monitoring what your competitors are doing, what you are doing, what might be your new IP assets, and what are your new business goals. And really an IP strategy is saying, what am I doing in my business? And then turning the mirror the other way to say, what are the IP implications of that change? And then what do I want to do about them? Next slide, please. I just automatically did page down, and of course it's not doing anything. So as a recap, identifying what intellectual property you have is a really good step. And that checklist that we provided the link for, I find that really useful and very user-friendly. Learning about what are the intellectual property tools and who has what is really useful. identifying maybe some of your gaps. Nobody's perfect. I've yet to sit with any company or startup and they've done absolutely all the things they can do, because none of us are perfect. But at least having a roadmap and a plan helps you say, okay, in the next 6 months or in the next month, I'm going to do this. In the next 4 months, I'm going to try to do this. And in the next 6 months to a year, these are the gaps that I'd like to address and have a plan to meet these targets. And that is your plan for how you're going to use IP. And that keeps the IP in action and gives you kind of a checklist that makes it manageable and bite it off in smaller chunks. And always keep an eye on IP, who's doing what in your space. So I'll flip it back over to Giselle to talk about the resources that help you make all this come together.
Great, thank you, Catherine. So sorry, I just noticed we are over time now. So the last few slides I had for you were on CIPO's resources. So what I've done is I've just skipped to the contact page. Actually, I'll skip to one more just before it. So everything is accessible on our website, so cipo.gc.ca. All of our resources that I was going to go through and just provide a few examples are available under our IP toolbox. But one of our key resources I wanted to put up on this page is our IP advisors, such as Catherine, who is representing us in the Atlantic region. So we do have all of these IP advisors representing us from coast to coast. The link is on here. It's again also on CIPO's webpage, and you'll actually find their email addresses, so you can contact them directly if you need to follow up with any of the discussion, whether we had today, or you have any other questions about strategy and commercialization, or you're unsure of the IP you have. They're a very good contact to reach out to. They can also then probably make suggestions for other IP professionals that you can get in contact with as well. And then just lastly here on our contact page, you'll see Catherine's email there and mine as well if you did have any other questions. Sorry, we didn't have time to get, some people may have had to leave, and I just want everybody to know that if you have to leave, not a problem. You can always reach out with any of your questions that you have. Okay, so I think with that, I just wanted to thank again the WEOC for allowing us to present today. I'm just going to double check quickly if we do have any questions in our chat. 1 second.
And while Giselle is doing that, just to give you a little bit of information. So the IP advisors, I'm the one for Atlantic Canada. As Giselle pointed out, there are equivalents to me across Canada as well. And the way most of us work is you can reach out with an email. It's usually helpful if you give your name, your contact information, and a couple of sentences at least about what type of business you're in or what product or service you're planning to offer. And the way I operate, and most of us do, is we will book a 1 hour, whether it's via a video conference or teleconference, we'll book a 1 hour session with you to just have a kind of a roll up our sleeves and talk about what are your specific questions, or if you don't have you're not too sure, we can work with you to say, okay, well, what is your business? Tell me about it in a couple of sentences. And then we'll try to work through to say, well, okay, do you have a website? Well, have you thought about protecting a trademark? And we'll kind of peel back all the layers and work together to figure out answers to your questions, point you in the right direction to resources, and get you going again, and point you towards intellectual property, either agents or lawyers, depending on the expertise you need. I'm not a lawyer. Most of us who are IP advisors are not lawyers, so we can't give you legal advice. But what I do like to say is we try to prep you so that you have more of a base of knowledge. So you maximize your time with the lawyer, and they're not explaining to you what a trademark is. You can ask them your really pointy question of, well, I'm worried about a trademark infringement, and what about this existing one, and is that going to be an issue for me? As opposed to spending your dollars on having them explain to you what is a trademark and who else has trademarks that might be close to yours. I can certainly show you and help you look up what are the existing registered trademark. Though it's not an official search, it at least gives you more information going in. So hopefully that gives you a rough idea. So really, I have two roles. I give presentations like this, and I do one-on-ones with clients, whether that's an inventor or a business owner, and we try to help.
Okay, I think that wraps us up, I believe. I wanted to thank both of you, Giselle and Catherine, for this second presentation. It was so great, and I'm really looking forward to the next one. So I just wanted to remind everyone that we have a presentation on IP and traditional knowledge coming up on December the 9th with Catherine and Giselle to close out this series. But we have added on December 17th a French presentation that Catherine will be doing, again, on IP and traditional knowledge. So if those are topics that interest you or colleagues that you work with, please do join us. All of the information and links from today, as well as a recording of today's session, will be back up on our WEOC website, weoc.ca. And so you can share that with colleagues or revisit any information, and we will definitely put all of the contact information as well. So thank you very much, everyone, for coming and joining us today.
Thanks again for organizing this, and thanks to participants.
Yes, thank you.
Bye, everyone.